Good afternoon and welcome to this rapid response webinar, Reflections on the South Africa-Israel case at the International Court of Justice, held by the British Institute of International Comparative Law. I'm Jack Kenny, a research fellow in international law at the Institute and the convener of this event. Just a few small matters of housekeeping before we begin. A recording of this webinar will be made available shortly afterwards, and I'll also be drafting a meeting summary. So both of these will be made available online on the webpage for the event. If you enjoy this webinar, please feel free to also explore our other forthcoming events that we have advertised on our website. For the questions and answers part of this webinar, if I could encourage you please to submit your questions in the Q&A chat box. I'm pleased to say we have an excellent lineup of speakers today, and without further delay, it gives me great pleasure to introduce our distinguished chair of this event, Professor Dapo Akande. Dapo is the Shishel Professor of Public International Law at the University of Oxford, the Fellow of All Souls College, Oxford, and co-director at the Oxford Institute for Ethics, Law and Armed Conflict. He's a member of the United Nations International Law Commission and a barrister at Essex Court Chambers. Dapo, it's great to see you. Welcome. And when you're ready, the floor is yours.
Thank you very much, Jack. Welcome to all the participants that we have on this webinar. It's great to see that we have such high numbers of people on this event. So we're here to talk about one of the International Court of Justice's recent decisions. It actually is not its most recent decision, as the court has had two further decisions since this one was handed down just 2 weeks ago. As everyone knows, on the 7th of October, well, things turned upside down in the Middle East and maybe around the world more generally after the attacks by Hamas on Israel. And then we had the response by Israel in Gaza. And all of this has led to the government of South Africa filing proceedings at the International Court of Justice against Israel. And those proceedings were filed in relation to Israel's actions in Gaza, whereas we know over 25,000 people, we're told, have died so far. South Africa brought its case under the Genocide Convention, and at the same time, it also filed a request for provisional measures. The ICJ moved very quickly, scheduled the provisional measures hearings in early January, and has rendered its decision before the end of that month. It has generated huge interest, not just in the international law community, but in the world generally. And so this rapid response webinar is put together for us to discuss the proceedings, the court's order, and to look a bit into the future as well to see perhaps how these events might turn out once we get to further phases of this case. And to discuss these issues, we have a great panel of international law experts that will go through these issues for us. So I will introduce them in the order in which they will speak. First of all, we have Professor Marko Milanovic, who's Professor of International Law at the University of Reading. And after he speaks, we will then have Professor Paula Gaeta, who is a professor at the Graduate Institute in Geneva. And after her, we will have Dr. Danae Azaria, who's Associate Professor of International Law at University College London. And then we will have Professor Christian Tams from the University of Glasgow. Each of them will give some opening reflections on the issues as they see it for, say, about 8 minutes. And then after that, we will have a bit of discussion amongst ourselves, but we will leave plenty of time for Q&A. So please, those of you who are participating in this webinar, be prepared to put your questions and your comments. And as Jack said, you can do that using the Q&A function. So why don't we go straight into the discussion, and let's start with you, Marko.
Well, thank you, Dapo, and thank you to Jack, and thank you to Bickel for having me. It's a pleasure to be with you. So I want to just very briefly set the scene sort of how this order came about, and then discuss really the key issue in the order, which was this question of plausibility of the rights claimed. And then I will say just a few words about whether the order might make any kind of difference in the real world. Right, so in terms of scene setting, as Dapo said, South Africa sued Israel for genocide. The reason why it sued Israel for genocide is because it is only under the Genocide Convention, Article 9 of that convention, that South Africa could find a jurisdictional basis for the case, right? So there was no way in which South Africa could sue Israel for crimes against humanity or war crimes or for anything else or for human rights violations, simply because Israel has not consented to the court's jurisdiction for any of those types of acts. So the only thing South Africa could have done if it wanted to launch a case about Gaza was genocide. And then the issue with genocide is how do we distinguish genocide from other possible violations of international law? And Paulo will speak more about this, but the key issue here is the existence of this genocidal intent, an intent to destroy a group, a protected group as such. So the entirety of the case will really, both now and on the merits later in the case, will revolve around this question of intent. At this stage of proceedings, the issue that the court had to examine basically was whether the conditions for the issuance or the indication of provisional measures were met. One of these criteria is that it has prima facie jurisdiction, which it has because of Article 9 of the Convention. But as part of that, really, there's this whole question of whether the rights that are being claimed are plausible. Yeah. And the court really started using this language of plausibility relatively recently. So it was, if memory serves, it was only in the Belgium-Senegal case that dealt with Hissène Habré, which was, the order in that case was, say 15 years ago, that the court first used this term, plausibility. So for 50 years before that, the court did not use that exact terminology. And then there were a couple of other cases in which the court really tried to sort of do some kind of plausibility analysis. But the bottom line is there's no grand theory of some kind. The court never really explained in any kind of particularly reasoned way what exactly it means by this standard, by this word plausible. There are several separate opinions of the court's judges that do that. So it was Judge Abraham that I think actually first came up with this language. Then there was a really good opinion by Judge Greenwood in the certain activities case between Costa Rica and Nicaragua. And so we have those kinds of snippets of what the court might mean by plausible. Right? Now, in this particular case, essentially, the question was really factual, because you can really think of this question of plausibility as a primarily legal issue or as a primarily factual issue. I mean, let me explain. So, for example, in the Ukraine-Russia case, which the court decided on jurisdiction last week, there was the core of that case is really legal, or was legal. Whether the Genocide Convention contained a right that Ukraine could claim not to be subjected to military intervention on the basis of a false claim of genocide. That was the framing of that case. And at the provisional measures stage of the case, the court said that right is plausible. Last week it said by, was it 12 votes to 4, that no, that right does not exist. Now that is a primarily legal inquiry. It's a question of interpretation of the convention. By contrast, here in South Africa versus Israel, the question is really factual, right? South Africa and Israel, they agree essentially on what genocide is, on what the elements of the crime are, even on basic questions of how does one establish intent. There wasn't like a huge amount of disagreement between the two parties in that case. The law is actually relatively settled. So the question really was factual. From looking at all of the evidence in the case, was it plausible for South Africa to argue that Israel was committing genocide in Gaza? That's the core question. And by plausible in this context, the court really means some low level of possibility. So not something that is likely, yeah? Certainly not something that is certain or convincing. It's just something that is more than a mere allegation, yeah? And South Africa could meet that relatively low evidentiary bar of essentially of, could it reasonably be argued? Is it possible that what Israel is doing in Gaza is genocide? And there are two reasons why it could do that. The first is the enormous amount of civilian casualties in Gaza. And the second are the statements, the really horrible statements made by some Israeli officials. And it's those two things combined that led the court to conclude in paragraph 54, this is really the core of that order, that some of the rights alleged by South Africa are plausible. Now, this is the first time the court actually used this kind of formulation in a provisional measures order. So when Gambia sued Myanmar, for example, for genocide, the court did not say some of the rights alleged by Gambia are plausible. The reason why the court uses this particular formulation is probably because there was actually quite a bit of disagreement among the judges about whether Israel plausibly is acting with genocidal intent. But anyway, South Africa got that. The reason why it got that is because of those statements, essentially those statements by Israeli officials. Had they not uttered those words, it is, I think, very possible that the court would not have issued a provisional measures order. But what does this generally means is that when you have an inter-ethnic, inter-religious conflict of the kind you have between Israelis and Palestinians, and you have a large amount of civilian casualties, the plausibility criterion will easily be met. And then that brings me to the final word I wanted to say. Will this order make a difference? It's a bit, like the French Revolution in the words of Zhou Enlai, it's too early to tell. Yeah. So we will know whether this order made a difference probably a few years from now. We can't really know. We can just speculate. There are some bits of the order that just repeat, basically, the state's parties' obligations under the Genocide Convention. That doesn't mean they won't have an impact. There are bits in the order that essentially tell Israel it has to curb direct and public incitement to genocide, and it has to release, make more efforts to provide humanitarian assistance to Gaza. Now, we have seen the defunding of UNRWA, which doesn't exactly comport with that last sentiment of the court, but that does not necessarily mean that in the months to come, the order won't make any difference on the humanitarian assistance front. We shall see what the Israeli Attorney General does about hate speech and incitement to genocide more generally, and whether that will provoke any kind of cases. Certainly, one possible impact is that the order will factor into the assessments of third states who are assisting Israel. And there's already litigation in several countries of that kind. We will see I think, very shortly, an appeals judgment in the Netherlands that deals with the transfer of airplane parts to Israel. And it'll be very interesting to observe whether the court's provisional measures order factors at all in the reasoning of the Dutch judges. So it certainly may make an impact in that sense. So I'll finish here. Thank you so much.
Thank you very much, Marco. Thanks for that great overview of the provisional measures order and the possible implications that it might have for other states. Now let's turn to Paula. I think Paula's going to talk a bit about the provisional measures order, but more generally about this point that Marco raised, claim under the Genocide Convention, but actually more general allegations of violations of international humanitarian law. So over to you, Paula.
Yes, thank you so much, and thank you for inviting me. It's great to have the opportunity to have some preliminary reflections on this case. And I think Marco put it very well, the setting, the scenes, and so on and so forth. I would like to be a bit more analytical on some issues that he has already introduced. First of all, I would like to focus a bit more on the content of the measures that the court has ordered to Israel. And secondly, on the relationship between IHL, international humanitarian law, and genocide. When it comes to the first aspect, Marco has already said it, the provisional measures are requested and can be issued to protect the rights claimed by the parties. And therefore, there is a link between the provisional measures that the court can order and the merits of the claim. That's an important aspect to consider. And South Africa has claimed a variety of things. It has claimed that not only Israel, by conducting this kind of war on Gaza, is committing itself genocide as a government, as a state, and eventually any other of the acts prohibited by Article 3 of the Convention, which include incitement to public and direct incitement to commit genocide, complicity in genocide, attempt to commit genocide, which is also important in this case, perhaps. And on a different level, it is also claimed South Africa that individuals acting as organs of Israel, so at the individual level, are committing genocide or any other acts prohibited in Article 3. So we shall keep this distinction very clear, no? The possibility that Israel itself is committing genocide or other acts prohibited, and the fact that individuals acting as organs of Israel are committing genocide or public and direct incitement to commit genocide, and so on and so forth. And it is in respect to the first claim that South Africa has requested the court to ask Israel to stop its military operations on Gaza. And the court has not given to South Africa this provisional measure, which has left South Africa and the Palestinians a bit unhappy about it. But to make something like that, for the court to claim, to order Israel to stop the military operations on Gaza, this would have implied the court to assess the plausibility of the claim, that the actual reason behind the war, that the war on Gaza is of a genocidal character. And this was very difficult for the court, I think, to reach as a decision at this stage of the proceedings, because Israel is claiming on its side that the war on Gaza is motivated by the need to protect own population, to free the hostages, and to eliminate Hamas in order to protect its citizens. And in general, it claims also self-defense. But I mean, the question is therefore whether or not this war on Gaza is of a genocidal character or not, has prevented the court for reaching a decision on the point of the plausibility of the right that the war, on the contrary, as South Africa is claiming, has a genocidal character. This is very important, I think, because in the genocide studies, there is a different understanding of what is genocide and war more generally. And you have basically two schools of thoughts. There is one school of thought that says, well, when there is genocide in wartime, one has to be very careful in equating mass killings and civilian casualty in war from genocidal violence, okay? So you really needed to prove that the kind of pattern of military violence in armed conflict has a genocidal character. And this is something difficult to prove, because you can always say that you are aiming at a different kind of, that the military force is motivated by some other different reasons. On the contrary, there are other scholars who claim that given the possibility to use methods of warfare that have highly indiscriminate character or can lead to total destruction in warfare, this can characterize itself the war as genocidal. This is perhaps a bit confusing, but I think it's very important because also in past cases, so for instance, in Bosnia versus Serbia, Croatia versus Serbia, and the Clanto claim Serbia versus Croatia, this was very important, is how you demonstrate that a state which carrying out a war is actually carrying out a genocidal war or not. This is a fundamental aspect to be decided. But leaving this aside, I think that the court has focused in its provisional measure order, in particular, on the protection of on the part of the claim of South Africa, whereby South Africa is accusing organs of Israel to be committing genocide or public and direct incitement to commit genocide. And indeed, if one reads the first three measures that the court has issued, they ask Israel to first ensure that measure to prevent the commission of genocide in Gaza, which is an obligation that Israel already has under Article 1, but also to ensure that its military do not commit genocide. Again, it's a reinforcement of the obligation to prevent genocide from Israel vis-a-vis the military. And third, to ensure that people do not commit the incitement, public and direct incitement to commit genocide. So this is measures that Israel has to take vis-a-vis the plausibility that some individual organs of Israel are committing genocide or any other of the acts prohibited by the Genocide Convention. Of a different type, I think, is on the contrary, the fifth provisional measure that the court has ordered, namely the fact that Israel must guarantee the preservation of evidence demonstrating the possibility that genocide is committed or any other acts prohibited by the Genocide Conventions are being committed. The preservation of evidence, of course, can be seen in a twofold manner as let's say, something that one has to ensure that Israel complies with its duty to punish genocide and any other acts prohibited at an individual level, but also because the preservation of evidence may be useful in the future for the court to assess whether or not the government of Israel has a genocidal intent during the war. Because if you manage to prove that some senior state officials in the government of Israel have in fact a genocidal intent and you preserve such an evidence, it could be easier or could be important in the future for the merits of the claim to prove or not to prove that Israel as a state had a genocidal intent in this war. Now, finally, I don't know if I have time. I don't have much time, but if you allow me, Dab, for just a few minutes more, I was reflecting about the relationship between IHL, international humanitarian law, and genocide, because I've heard some scholars saying that if during a war, attacks on civilians are a result of collateral damage and they are not therefore prohibited under international humanitarian law, these may not be genocidal killings. The actus reus of genocide would be missing because those acts are not prohibited by international humanitarian law, namely collateral damage which is proportionate would not allow to claim that the genocidal acts of killings are committed. This is a position that Israel has put forward in the pleadings. And I was thinking, it's strange. To me, the two are totally separate because something that may be lawful under international humanitarian law may not necessarily be not constituting a prohibited genocidal killing under the Genocide Convention, because to me the two things are separated. It's another question to prove the genocidal intent, but the actus reus of killing for genocide may exist, even if casualties among civilians are proportionate or disproportionate. It doesn't matter. No? So IHL has no bearing on a genocidal finding. And I went to the Croatia case, and therefore Marco has commented upon it, so I speak under his control. And I bumped into a passage of the ICJ decision in the Croatia versus Serbia case concerning the counterclaim of Serbia vis-a-vis Croatia. And there the court discussed, in general, it said, well, it is possible that IHL has no bearing on genocide. However, the court has said that if the, in essence, if an act under, if the killings of, if a military attack is not unlawful under IHL, namely if civilians have been not killed deliberately, there cannot be the actus reus of killings for the purpose of genocide. Because according to the court, for killings to amount to genocide, these killings must be intentional. And therefore, according to the court, if civilians die, are not targeted deliberately, then, and therefore they are targeted collaterally, then there is no killing of civilians, which would count for genocide. And to me, this statement is utterly problematic, because I think the court confuses two things, the lawfulness and lawfulness under international humanitarian law, and the intentionality of the killing. Because if during an armed conflict, I target, I don't know, a military objective, such as an hospital, because there are weapons of or there are combatants in the hospital. And I know that in order to attack the military objective, I need to cause the death of civilians or people who are in the hospital. To me, the killing of those people, of those civilians, is intentional in criminal law terms. Then if they die in a proportionate manner, these killings would be not unlawful under IHL, but this does not mean that the killings of these civilians as collateral damage are not intentional. So I don't see how the court has made this very dangerous statement to me in the Serbia versus counterclaim versus Croatia in that case. But this is a matter on which I would like to elaborate a bit more in the future. Thank you so much.
Thank you very much, Paola. Maybe we'll come back to those questions in Q&A. Interesting questions about the relationship between IHL and Genocide Convention. Okay, let's turn now to Danae Azaria, who will talk about some of the arguments that were made in those proceedings at the provisional measures stage relating to the dispute between the parties. So over to you, Danae.
Thank you, Dapo, and thank you for pronouncing my last name correctly. Now, at the provisional measures stage, the court must first be satisfied that it has a prima facie jurisdiction to rule on the merits. In its provisional measures order in South Africa versus Israel, the court found that it prima facie had jurisdiction because it appeared that South Africa and Israel held clearly opposite views as to whether Israel's conduct violated the Genocide Convention, and thus there appeared to be a dispute. The court also considered that the conduct complained of appeared to be capable of falling within the provisions of the convention, and expressly without examining, and contrary to Israel's argument, whether or not there was genocidal intent. Now, the court had taken the same approach earlier in the provisional measures in Gambia versus Myanmar too, and so the court's reasoning on this aspect is not surprising. Thus, at the stage of prima facie jurisdiction, the crucial question was whether there was a dispute between South Africa and Israel on the basis of an objective determination of the facts. And I will focus on the existence of a dispute in this case, taking into account the parties' pleadings and the court's earlier decisions. So in the following minutes, first I will comment on the function and timing of the dispute's existence for the court's jurisdiction. And second, I will discuss the evidence on which the court relied in order to establish that the dispute existed. But before going into these comments, allow me to remind everyone what is meant by dispute. Now, the Mavromatis definition, a disagreement on a point of a law or fact, a conflict of legal views or of interests, is undoubtedly generic and abstract. And the court has since clarified, notably in Southwest Africa, and reaffirmed consistently since, and in fact, even in this order, that for a dispute to exist, it must be shown that the claim of one party is positively opposed by the other. Now, in real life, two states may be involved in actions, statements, inactions, silences, and at times in direct exchange with each other, and on other occasions independently from each other. And a dispute may be generated owing to various conducts and statements until eventually it comes into existence, it crystallizes. And this brings me to the importance of the function and timing of the dispute's existence. So in South Africa versus Israel, the court considered, as it has done in its recent case law, the existence of a dispute, that the existence of a dispute is a condition for the existence of its jurisdiction. And additionally, the court considered whether the evidence established a dispute prior to filing the application. So the court's reasoning is consistent with its reasoning since Marshall Islands. And I think it's also significant that both parties agreed in their pleadings that the dispute must exist prior to filing the application. Now, moving to the evidence on which the court relied to establish prima facie the existence of a dispute, allow me first to briefly explain the court's reasoning. Now, the court recalled in its earlier case law, according to which it takes into account in particular any statements or documents exchanged between the parties, as well any exchanges made in multilateral settings. It found prima facie dispute by relying, however, on the combination of South Africa's public statements and a public statement by Israel. Now, on the one hand, the court indicatively and expressly relied on a statement made by South Africa at the 10th Emergency Special Session of the United Nations General Assembly on 12 December 2023. And more specifically, South Africa has stated then that the events in Gaza have illustrated that Israel is acting contrary to its obligations under the Genocide Convention. Now, although the court did not state so, it seems that this statement makes a clear legal claim, both in terms who is the addressee of the claim, and in terms of the conduct being complained of, and in terms of the subject matter of the claim. Now, the court further noted that Israel was represented at this meeting, and it also noted that South Africa recalled this statement in its note verbal of 21st December 2023 to Israel. Now, again, although the court did not state so, it can safely be assumed that the court asserted from these circumstances Israel's presence in the General Assembly and the receipt of the note verbal, that Israel was actually aware of South Africa's claim since at least the 12th of December 2023. In other words, the court continued to rely on its reasoning, especially since Marshall Islands, that for a dispute to exist, a prospective respondent must be aware or could not have been unaware of the prospective applicant's claim. On the other hand, the court did not stop there. It also relied on a statement by Israel, which had expressly dismissed any accusation of genocide in Gaza. And this statement was made in a document that had been published by the Israeli Ministry of Foreign Affairs and was reproduced on the public website of the Israel Defense Forces. Now, first, what the court did not do is important. The court did not reason that a dispute existed by virtue of Israel's conduct in Gaza, on the one hand, and South Africa's subsequent complaints against this conduct, on the other hand. I have some views on this subject, but perhaps we can discuss it later. We have time. Second, Israel had argued that the evidence submitted by South Africa did not prove that there had been any direct exchanges between the parties, and thus no dispute existed. South Africa, Israel argued, did not give Israel a reasonable opportunity to engage with it on the matters under consideration before filing its application. Now, in its order, the court impliedly, but consistently with established reasoning in its earlier case law, has rejected that prior negotiations are required for a dispute to exist. However, the court's reasoning seems to also imply that the statements of South Africa and Israel fell within the concept of exchanges. Now, it is true that the court has not explained in this order or in its earlier decision what it means by exchanges between the parties. And the term certainly does not require prior negotiations, we know this. And exchanges may be informal and can take place bilaterally or in a multilateral setting. And Georgia versus Russia, Gambia versus Myanmar support these propositions. But I think the court's reasoning in South Africa versus Israel also confirms that the exchanges can also be indirect, as long as the claims are connected in their substance. And it also is important that for the court, these claims can also be made through modern communications technology on a public website, for instance. And third, the parties made arguments concerning Israel's alleged silence in response to South Africa's note verbal. Now, the court did not address this issue, but I hope that we can discuss later the connection of state silence with the existence of a dispute in this case. Thank you very much.
Thank you very much, Dene. Last speaker in this first round, Professor Christian Tams, who will reflect on the case a bit more widely. Over to you, Christian.
Well, thank you, Dapo. Thank you to Bickel, Jack, and all others to organize this. It's very good to be part of this panel. Excited to be speaking about this. Now, my idea for the next few minutes is to step back, indeed, as you suggest, and reflect a bit more broadly about implications of this case, which so far I think we've discussed almost as if it was a traditional interstate case. I mean, I think, Dapo, you mentioned at the beginning the unprecedented public interest in the case. But so far we've focused on proceedings brought by one state against another. Is there a dispute? We have asked whether sort of the court's order of 26th of January fits with its previous jurisprudence. And all this is, of course, crucial. You could say that's the bread and butter of a legal analysis of this process. But I think there is perhaps a further dimension, which I would like to highlight in the remaining minutes of this opening round. And this is a key factor of these proceedings, that while they are a bilateral ICJ case, they are really a multilateral dispute of global concern. And therefore, not just in terms of the public interest that you mentioned, but also the interest of states that are not formally party to these proceedings, but have taken positions vis-a-vis the dispute. And they have felt an urgent need to position themselves vis-a-vis the issues that have been raised. It seems to me that this is a very general and basic, but perhaps straightforward point, that if we want to assess the impact of this case and evaluate the proceedings so far, we need to take those statements by non-party states into account, and we need to sort of factor them into our assessment. And that's what I want to do. And in that respect, I want to make three relatively brief points. First is, I think, from the record of states taking a view as non-parties on the feasibility and merits of this claim, we can see that the ICJ is quite a powerful forum in shaping a diplomatic discourse about matters of international law. So that's the first point. Secondly, I think if we engage with these statements, we need as international lawyers to leave our comfort zone and perhaps work with factors and parameters that are not conducive to appreciating dispute settlement before courts normally. And third and final point, also briefly, it seems to me that the ICJ procedural regime at the moment isn't really suited to integrate statements by third states into the process as such. So first point then, I think there is really sort of a rich body of international practice, of pronouncements, of expressions of view on the merits of this case. Dozens of states have since late December taken a view on whether they thought South Africa's case was welcome or an abuse of process or merited to be sort of seen through or was implausible. So the points that Marco in particular sort of initially argued, the plausibility of the claim, has been taken up by many states who have expressed views on this. Now, it's easy for us to dismiss this as statements that are perhaps made off the cuff or reflect biases of states looking to this dispute. They're clearly not based on a clear study of the material that it was presented to the ICJ, because many of these statements were made earlier than the proceedings even began. But I do think if we're looking at them in the round, we see quite a lot of specific and detailed engagement with the issues. So states like Malaysia and others have said that they found Israel to be in breach of the Genocide Convention. Other states have said that they couldn't, taking up a point that Paola spoke to, that they couldn't see that a state acting defensively could ever plausibly be accused of genocide. Since the order, we've had a similar vocal response commenting on the proper interpretation of the order. And for example, assessing whether the defunding of UNRWA that Marco mentioned would amount to a violation of points made in the order, or Israel's conduct on the ground, let's say not permitting certain forms of access, would violate its duties. Now, all this could be scrutinized, of course, by the court as well, but third states are taking views that are quite specific, I think. And so I would say that generally, it's not, of course, discussion about this dispute, the Gaza war, that, as you said at the beginning, Dapo, shook the foundations of our perception since 7th of October, has begun with these proceedings. But I do think it has increased in volume significantly. It has brought in a lot more states taking views, and it has resulted in greater specificity. And I do think that one thing we can take from this is what I want to articulate as my first point. We see a real crucial quality of ICJ proceedings in this case that goes beyond the legal assessment. They are a factor of global public diplomacy which amplifies the discourse, amplifies interest in issues, and that focuses the discourse on legal matters. So that's, I think, the first point, which is sort of the material that we need to work with. My second point goes more perhaps to the international lawyers in the audience or to us on the call. I'm wondering whether as international lawyers we have the tools or the parameters or the concepts to address that. It seems to me plainly relevant, these amounts of public interest, when we look at what is done with the ICJ order, with the impact. As Marco was saying, it may be too early to say and to measure the impact on the ground. But if we measure the impact of the order at some point on global public conduct, it seems to be that these statements and reactions following the taking of positions are a dramatically relevant source of empirical assessment. States will have reacted to the defunding of UNRWA, the withdrawal of funds, by others. States will have taken a view on what Israel does and criticized it. This is all part of a public discourse, and in international law, we so often have to work with auto-assessment and auto-determinations of the participants immediately concerned, that here I think we have a rich body of genuine, sincere engagement with a crucial legal issue. Can we factor that in as international lawyers? It seems to me that a few things are very clear if we want to come to terms with the impact of a court on global disputes, on major conflicts like this one. It seems to me that we need to move out of this idea that binding dispute settlement by the court is the necessary next step after negotiations or when diplomacy has failed. Here we clearly see the possibility of a court process to trigger new diplomatic initiatives, to perhaps shape diplomatic initiatives of conflict resolutions, to force the hand of certain players, to draw in third parties that are not parties to the proceedings. And I'm wondering whether as international lawyers we have the concepts to assess that. And the second point to perhaps also raise that as a question, I mean, when I look at, I mean, sometimes sort of look at sort of how our textbooks treat international court proceedings as part of the peaceful dispute resolution process. And the focus is on compliance as the major indicator of impacts. I mean, compliance, is that really a factor? We need to look at the impact or the court as triggering responses by third states. That's the relevant factor we need to look at, not study again for the 150th times whether provisional measures by the court are complied with by the party concerned. So I think what we can take from this richer material of practice is for international lawyers to stop writing about court proceedings like this as part of sort of, if you want, a litany or a sequence of peaceful dispute resolution procedures going from negotiations via mediation, conciliation to arbitration and adjudication, and assessing compliance as our central benchmark for the effectiveness or success of proceedings. A final point, and much more briefly, is the ICJ prepared for this? This interest in the proceedings. It seems probably to me that it's not. It has opened up its procedural regime for litigation about multilateral disputes, has done so for a while, and has, as some of you will be aware, with the judgment in the Gambia-Myanmar case, recognizing the public interest standing of applicants to bring proceedings for breaches of public interest rules. It has now, if you want, officially ratified the position that there can be disputes brought by applicants that are unusual applicants, perhaps. But if we're looking at the interest by other states that are not claimants, it seems to me that the ICJ's regime is not and can perhaps not be suited to accommodate that very much. We see, of course, the main aspect as sort of the main venue or avenue for third states to be involved in the proceedings is intervention proceedings under Article 63 or Article 62 of the statute, and this has been used in the case between Ukraine and Russia that Dapo hinted at in the opening remarks. It is also very likely to be used in the present case. At least very many states have already announced that they would intervene, and Nicaragua, I think yesterday it was on the news, has announced that it would intervene not as a state interested in the construction of the convention, but as an intervener under Article 62. But how far can that carry? it seems to me that the practice with the case between Ukraine and Russia shows that the courts and the parties are still coming to terms with these procedural tools, these procedural vehicles, especially the interventions under Article 63, which seem to be happening now again in this case, probably have a more limited role than the states rushing out with statements that would intervene on this side or the other anticipate. They are limited, as the court has made relatively clear in the last year in its order on interventions between Ukraine and Russia. They're really limited to the construction of the convention that is at stake. So for very fact-heavy disputes like this one, they may not allow states to do what they signal, namely to intervene on the side of state A or state B, simply because the intervention is meant to be legal and interpretative in nature. So it seems to me generally that the ICJ's regime probably, despite opening up to permit public interest litigation by claimants such as South Africa, will not be opening up to find proper room for the wide measure of public interest that we have seen in this case. This isn't a plea for reform. It may be just that it is as it is, and we will have to treat these statements as a rich body of state practice accompanying and triggered by and focused by international litigation. But that is a task for international lawyers. And as I said in the middle of my intervention, I think as international lawyers, we have, most of us, a bit of homework to do to come up with the right categories to assess this properly. That's all I wanted to say. Thank you, and back to you, Dapo.
Thank you very much, Christian, and thanks to all of you for your statements. Just to encourage the participants that you can put your questions in the Q&A box. There are already a few questions there, and we will come to those questions in just a moment. So what I want us to do is maybe spend a little bit of time actually digging into the court's order, and then spend some time looking at the future with regard to this particular case, where the case is likely to go next. But in relation to the order of the court, I wanted to come to you, Marco, just to talk a bit about actually what the court did not do in this particular case. And somebody's actually already asked this question in the Q&A. Alexa's already asked this question. South Africa did request that the court issue a provisional measures order requiring Israel to cease the conduct of the military operation. The court didn't do that. It had done that, though, in the Ukraine versus Russia case, also brought under the Genocide Convention. And so the question really is, why did the court not do it in this case and do it in that other case? Is there something that's similar or different which serves to explain that difference in treatment?
Thanks, Dapo. I think there's a formal reasoning behind this, and then there's probably the real reasoning behind this, right? So the formal reason behind distinguishing the two cases is that they're actually very different. So in this case, the claim is that Israel is committing genocide, and that the entirety of the conflict or the war that it is waging in Gaza is genocidal. Whereas in Ukraine versus Russia, it was in reverse. Yeah, Ukraine's argument was Russia invaded us on the basis of a false accusation that we committed genocide against our people. And so the court could say in that case, the entirety of Russia's military operation is plausibly predicated on a false assertion that Ukraine committed genocide. And that's why we can tell Russia, stop all of it. Yeah. Whereas here, the situation is different. Now that brings me to the real reason, probably. In the Ukraine-Russia case, what Russia did was so obviously unlawful and wrong on any kind of moral policy sort of measure. In this particular case, it is more complicated, both as a matter of morality, as a matter of policy, or however you want to frame it, right? There was the 7th of October. 1,000 something Israelis were killed by Hamas. Hamas is there. Hamas did take all those hostages, right? So it's not like a morally black and white sort of picture of Ukraine and Russia, right? And in that sense, Israel can equally plausibly argue, actually what we're doing is self-defense. It is compliant with IHL and so on. It is not genocidal and so on and so forth. So it's the combination of these two things really that meant that the court would not order Israel to stop. Yeah. and that it did what it did. For, you know, whether one is happy with that or not, but that's why they did it.
Thanks, Marco. And looking sort of further forward, this, of course, was just the provisional measures phase. We've talked about plausibility of rights. Paula, maybe I can come to you next, and maybe some predictions as to where the case goes next. So now looking at the actual claim that South Africa has made in this case, any predictions as to whether South Africa is likely to be successful on any aspects of that claim or not?
That's difficult because, as we know, the court will pronounce itself on the merits in the years to come. No? So it also depends on what will happen on the ground, I think, and the subsequent activities on the ground. As things stand now, when it comes to the allegations that Israel as a state is committing genocide, I think the court will have to come to terms with something which was an ambiguity in the Bosnia genocide case that I've criticized, but then the court has tried to solve this ambiguity in the Croatian case, but not yet entirely, whereby when you decide finally that under the Genocide Convention, states are prohibited from committing genocide, and you have to apply this very criminal law kind definition of genocide onto a state to establish its commission of a wrongful act, then you have a problem in defining when a state has a genocidal intent. Okay, that's we know very well. And the court in the Bosnian case, it was a bit ambiguous because it seems to say if the leaders as state organs of a country have a genocidal intent, then we can transfer such a genocidal intent onto the state. And this would be one case for having genocide. But it went even further and said every person acting as a state organ of or as an organ of a state having a genocidal intent may imply that the state is committing genocide. So as we see, if we apply this standard, if there are cases against the plausibility or there are evidence that leaders of the state of Israel, current leaders of the state of Israel, or members of the military are committing the crime of genocide, then Israel is committing genocide regardless of the purpose of the military campaign, even though even though the overall purpose would be to be enacting in self-defense and so on and so forth. So the court will be obliged to say something about that now. It cannot really avoid the problem. And I think this would be something, I don't know what the court will say on this aspect, but it's a question that the court has to tackle for sure.
Can I come back to Marco on this question, because you've also written on this issue of whose genocidal intent matters when we're dealing with state responsibility for genocide. So how do you see the merits of this case playing out on this question and more generally?
So on the question on principle, my view is actually relatively simple. It doesn't have to be the leadership of the state that possesses intent. The state is responsible for the conduct of all of its organs. If you find a colonel and the colonel has genocidal intent and committed the acts that constitute genocide, the state is responsible for genocide. In the same way that if, I don't know, a regular soldier rapes a civilian, the state is responsible for that rape. It doesn't have to be, the particular mens rea was shared by the leadership. So that is my view. Now, the question is whether the evidence will bear this on the facts. And the court in the Croatian and Serb and Bosnian cases said basically it needs to be fully convinced that there's genocidal intent. Remember, the absence of genocidal intent doesn't mean that Israel is doing good things. It could still be committing crimes against humanity and war crimes. It's just that the court would not have jurisdiction over it. That's exactly what happened for the majority of claims in Bosnia and all of the claims in Croatia, right? So my prediction, which is I would say pretty confident, is that in the end, that's what's going to happen in this case, that unless the evidentiary record is substantially developed compared to what we know now, or the court changes its legal view so that it relaxes evidentiary requirements, which I don't see it doing, the outcome here will be the court will say, maybe there were horrible things, but there was no genocide. Now, one thing that I find very interesting before we get to the merits is preliminary objections. So I think Israel now actually has an interesting strategic dilemma. which is whether to object to the court jurisdiction and the admissibility of the case, for example, using all the dispute stuff that Danai was talking about, or whether not to object. Now, historically, states object all the time, and that prolongs the case. It adds a couple of years always to the case. But it could be that strategically, Israel's interest might be not to object. Because if it does not object, if the case moves quickly to the merits, all of the fact-finding apparatuses that might exist, like a UN Commission of Inquiry, et cetera, might not have the time to develop the factual record of genocidal intent. You see what I mean? So there could be, I'm not saying this is what's going to happen, but it could be that Israel actually says, let's go to the merits as quickly as possible. It could be in their interest to actually do that.
Can I come to you, Danae, on this question of preliminary objections, because it relates precisely to the point that you've been making. So at the provisional measure stage, of course, the court is only looking at whether it has jurisdiction prima facie. So all the things you talked about, the existence of a dispute, the court hasn't actually decided any of this in terms of whether it has jurisdiction. We saw, of course, what happened just last week or the week before last in the Ukraine-Russia case, where having ordered provisional measures, the court then decides that actually what Ukraine really wants, the court does not have jurisdiction to decide. So, Danae, the question that I really want to ask is, if Israel does decide to object, and if they decide to object on grounds of jurisdiction, how do you see that playing out? Do you think that on both the dispute point that you raised, but also perhaps on other points, there are good grounds in this kind of case for saying that it all falls outside the jurisdiction of the court?
Thank you, Dapo. Given that you're right, that of course, in the provisional measures stage, the decision is a prima facie. So the court, in other words, has found that there appears to be a dispute. So it has to find, first of all, whether there is a dispute in relation to its jurisdiction. But I would personally find it very difficult now, after this finding, for the court to actually find that there is no dispute about the Genocide Convention. So, and especially given the evidence that the court relied on in this particular context, by doing this on the basis of two opposing express claims. So I would expect that it would take the same position in the preliminary objections phase as well. But can I perhaps make one comment that connects a little bit on what Christian was saying? And I tend to agree that there is an aspect of global public diplomacy, but Christian, I do not see this as something extremely exceptional for the court in terms of, because it depends on the vision that we have about international law. And in my view, international law is just another means through which states conduct their international affairs. And of course, diplomacy goes hand in hand with this. So that the court, that they could go into the means of relying on international law and going into the court is not perhaps the most extraordinary aspect of the case for me. I think what I find particularly important for this case, besides the public interest litigation, which I agree is important, is the fact that we have now states, and especially from the global south, calling the court to decide and play a role in major global political situations, and especially where other organs of the United Nations have been unable to act. So I think that's particularly an aspect that I find interesting in this case. And I expect that a lot of lessons will be learned, but we need to remember at all times, this is just one of the means, but this particular means has limitations. The court will always have to establish jurisdiction. And so all this discussion about whether there is a dispute, especially in a contentious context where it's adversarial and you need to prove that it is also a bilateral dispute, despite the fact that it is outside the court, multilateral, will still have to be proven. Thank you.
Thank you very much. We have already a number of questions in the Q&A, so please put your questions, keep putting your questions there, and I'll pick up on them. And let me just pick up on a couple of questions in the Q&A. So some people are asking about the impact of the court's order. So there's a question in there by Gosego who's talking about the impact of the ICJ's findings. And then there's a question also by Paba who's talking about, who's asking us to reflect on the assessment of plausibility in terms of the implications of that. And what I want to focus on, first of all, is the impact on third states. And Christian, you talked about this, that we shouldn't just focus on whether or not Israel complies, but what implications does it have for third states? And as Marco mentioned in his remarks, one of the questions that's raised is, what does this mean for third states who are, for example, supplying arms to Israel? Does the order itself mean that they now have some kind of duty not to do that? Especially given that all parties to the Genocide Convention and presumably all states have an obligation to prevent genocide. So one of the arguments that's sometimes made is that, well, the court has said it's plausible that there's genocide, plausibility of rights. This therefore means that third states must take action to prevent. So Christian, can I come to you to just tell us a bit about your view of whether this has any implications for third states' obligations to prevent genocide?
Yeah, thanks. I mean, I think I probably do this in two stages. Sort of, I think formally I see relatively little in the order that would require third states to change their conduct vis-a-vis Israel. All the measures are directed at Israel. So the state of Israel the state of Israel should do this, should do that, which is different from what South Africa had requested, namely an order of erga omnes directed at itself, Israel, and perhaps then by implication third states, that they must do everything to prevent genocide. So that order, that preliminary order request was not granted. So in that sense, the sort of the ICJ order of 26th of January doesn't address the potential bystander responsibility. As you say, Dapo, that's not the end of the matter, because the responsibility, if anything, flows from Article 1 of the Genocide Convention, the duty to prevent, which exists irrespective of the court's order and exists separately from that. So the question is whether, in light of the court's order, this duty of prevention has now been focused, and that states are now, if you want, no longer able to make certain arguments suggesting that they would need discretion to determine their course of conduct. And duty to prevent might mean, for example, not engaging in a particular form of conduct, let's say support or delivery of weapons. This has gained significant acuity with press reports that Nicaragua was preparing a case against some states engaged in the supplying of weapons to Israel and accusing them of breaches of the Genocide Convention by complicity in genocide. I think these are so far unconfirmed news reports, and I haven't seen any claim to that effect, but it seems to be a very live issue. I would say that, I think those claims are not obviously plausible. People may form an opinion about the desirability or not of weapons deliveries to Israel, but at the moment, it seems to be unclear whether weapons are used, whether that's part of a general policy, whether they have any impact on the ground, whether the delivery of weapons isn't accompanied by limitations on the use of weapons or insistence that the weapons ought not to be used in a certain way. I don't have any inside information about these matters, so don't read this as a sort of a suggestion that there couldn't be any legal angle on enforcing that duty. But at the moment, I do not see the delivery of weapons as such without more as a breach of the duty to prevent. Thank you.
Thank you. So implications of the order for third states. Let's actually go one step back and look at the implications of the order for Israel itself, right? So we've talked a bit about the order, but what exactly does the order require of Israel to do? And there's some questions in the Q&A that point in this direction, that's kind of asking us about this. So there's a question by Emmanuel who's saying, look, the campaign has more or less continued after this. And there's also another question, yes, it's a question by Daniel Purish, where he's really asking us to interpret the order in terms of Israel's own obligations under that order. So he asks whether there's some ambiguity in the fact that the court does not expressly mention the special intent. And so he asks us, what would we say to observers that have interpreted the order as requiring Israel to stop all killing of Palestinians, because the order just says Israel should not commit the acts that constitute the actus reus of genocide? Paula, any thoughts to that?
Yes, I thought of it also, but the court is a bit ambiguous, but it says that these genocidal acts comes under the purview of Article 2 if they are committed with genocidal intent. So in a way, the court is not requesting Israel to stop killing Palestinians, but only to stop killings of Palestinians, not Israel, but to guarantee that Israeli Palestinians are not killed if this killing is done with genocidal intent. Implicitly, the court says it very well in the order, so that's not the point. I think it's something which is, if I may say something on this, it's about the bit of the order that concerns humanitarian assistance, which I think it's interesting there, because in this provisional measure whereby Israel is requested to enable humanitarian assistance, to reach Gaza. And clearly, this may be linked to the claim that the Palestinians in Gaza are under a condition of life calculated about to bring to their destructions under letter C of the definition of genocide. Which of course may mean that the court is plausibly convinced that this may be an impact on the Palestinian life in Gaza. However, again, we see here an interplay with IHL, because depending on how we classify the conflict, and therefore whether or not we believe that, I don't know, additional protocol 1 or 2 relevant provisions, namely article 70 or 18 of additional protocol 2 are customary law or not. I mean, what are the obligations of Israel vis-a-vis humanitarian assistance in Gaza? And there the provisional order is quite strong, I think, because it says without any kind of exceptions or justifications or whatever, without any reference to IHL, that Israel has to enable humanitarian assistance to reach Gaza, which I think is something that would be worth of exploring further, because as we know very well, Israel is claiming that certain humanitarian assistance items shall not reach Gaza on pretext that they, or explaining that they would be, helping Hamas to fight the war and so on and so forth. It's something that I would like to, perhaps other colleagues have views on that. I didn't think of it, but I think it's an important bit of the provisional order measure.
I don't know if anyone has any thoughts on that point that Paula has just made on humanitarian assistance. But one of the things that I also wanted us to think about is, so we talked about implications of the order for third states, and then there's implications of the order for Israel itself, which is what Paula has just been talking about. And then implications of the order, and in fact, the case as a whole, actually for the court itself. And so we see in the Q&A, there's a question there by Elia, I think, who asked this question about, sorry, I'm just scrolling through because, here we are. It's Elia English, who asks about the public interest in the case, and to what extent do we think that the court's findings will shape the legitimacy of the court and international law itself. So maybe if I go first to Christian and then maybe Danae, if you've got something on that too.
Yeah, thank you. I mean, I think that's a key question. I mean, at least for those looking at this, wondering about the role of the court. I mean, I think the case is fundamentally about the people in Gaza, but there is, of course, the role of the court that has to be taken into account. I mean, I think I agree that this is a test for the court, and I think it goes both ways. I mean, if we're looking at other major cases that prompted public interest in the court proceedings, there have been major tests for the court, whether that's Nicaragua. I think James Crawford said this tested the court's jurisdictional regime to the breaking point, and for some states beyond breaking point. Southwest Africa is sort of said the opposite. It's widely considered the opposite, where the court producing a sort of a narrow, perhaps plausible, but let's say not persuasive, a sort of too technical judgment is said to have lost the confidence of large parts of the then existing world. So I think these cases are test cases. I think I would say, and of course you can sense it, that the court probably feels the weight on their shoulders. I would say two things. One is the court has unusual potential to deal with these cases. Partly this goes back to what I was trying to bring out, that it's more, I mean, it's more than any other body capable of amplifying or focusing attention through proceedings. And that is significant, it seems to me. It's also, I think, one of the few courts that can deal with, I mean, we complain about the slowness of the court proceedings, but this is within 14 days, you had a public hearing on matters that were raised on the 28th of December. Look at the ICC. There is no provisional measure stage at the ICC. So if you want a quick response or a quickly accessible forum to address matters of pressing urgent concerns, then the ICJ is there and capable of dealing that. And that, I think, is a major factor. I think we're stuck. I think if we're looking at other aspects with limitations of the court, I think Dana spoke to this, Marco spoke to this at the beginning, jurisdiction is curtailed, so whatever is there on the merits will only be, I don't know, the tip of the iceberg or a fraction of the real issues. And then, of course, timelines are the other factor, where justice must be delivered properly and quickly, of course. In this case, you cannot really see the court having much of an impact, perhaps beyond the reporting duties now, because now this case will go into a year-long written proceedings phase. And who knows whether by the time of I think by the time of the eventual decision, there will still be interest, but it will be retrospective and it will be history-making rather than actual intervention in conflict resolution. For that, it's only the provisional measures that are there. And this is why I think they will watch with such interest. And I think, so those are factors that determine the court's approach and on which the legitimacy assessment, I think, will be based. Thank you.
Dene, can I come to you also on the impact of the order and the proceedings more generally on the court itself?
Yes, thank you, Tapo. I think that we have to recognize that the potential of the court to be involved in such public interest litigation or cases that concern highly political issues and multilateral disputes, then the biggest is also the risk for states to potentially lose their faith in the court, especially given that the court's jurisdiction has a consensual basis. So, and especially the question of whether a dispute exists, I think will become more and more an issue. It has already become an issue for the court increasingly, where it's actively pleaded in detail. But I think that the court at the same time is now called to be very rigorous and consistent in the way that it assesses the facts and evidence, and also to be more clear about the method for establishing that a dispute exists. And that's only an example. For instance, it has not clarified the weight that it places on different type of evidence, what type of evidence is determinative of a dispute, it is of probative value, what type of evidence has a confirmatory value. So I think it will be much more called to be at least rigorous and consistent and more clear about the aspects of jurisdiction. And certainly, I think there will be reluctance from the court to be wild about issues of jurisdiction. It will be much more express about how its jurisdiction is being established. Thank you.
Just before I turn to something else, I just want to highlight one comment in the Q&A from Jill Barrett, who's also talking about the impact on the court. And Jill says that having sat through UN debates about the performance of the ICJ and its funding, her comment is that any proposals for broadening the role of the court, however desirable, will hit two recurring issues at the UN. So the reluctance of member states to increase resources for the court and the difficulty of persuading more states to accept its compulsory jurisdiction, and that the court will be very mindful of this. So this is sort of setting this case into the broader context of actually what the court is dealing with. As we said, Christian's just mentioned that all of this happened incredibly quickly for the ICJ. But since then, we've had two further decisions. Court is extremely busy. And one question that one might ask is, the provisional measure standard that we've seen, that we've been talking about, is relatively low. But then on the merits, we're saying it's going to be relatively difficult. If the court continues to be this busy, and if the main impact is, as Christian was saying, the impact that you can have of provisional measures, all of this actually produces some perverse incentives to bring lots of cases at, so that you can get the big bang at the provisional measure stage, even though you may not actually get what you want in the end. And we've seen that the court in Ukraine, Russia, prepared to give a very far-reaching provisional measures order just 2 years later, then kind of knocking it out at the jurisdictional stage. So the question then is, how does the court respond to these kind of competing pressures that it's having? More cases, but then at the same time, it may well be that these cases in the end don't end up being successful, resource constraints. So any reflections on that would be interesting.
I mean, I suppose that the logical escape valve would be for the court to elevate the plausibility requirements and the other criteria for the issuance of provisional measures so that it actually becomes more difficult to indicate them. In the end, that's the only thing that the court could do, but I don't think we're there yet.
Can I come back to the content of the orders in this case and the implications of those orders? So we haven't talked about the more procedural things and the significance of the procedural things that the court orders. So there's a question about the reporting order. So Henry Levat asks a question there about the court's order that Israel report within 30 days. And somebody, I think, also asked, I think it's Tana Magota, asked also about the order on preservation of evidence. What impact do we think these will have? First of all, on the reporting order, will it be public, Israel's report? Will we know what Israel has said or not? And what impact, if any? Marco, do you want to take that?
So in the cases where this kind of reporting obligation has been done before, and that's Gambia, Myanmar really is the best such case. I mean, the reports were not made public. And so that removes the whole naming and shaming kind of aspect away. But that doesn't necessarily mean it won't happen. So one thing that could very well happen in this case is that Israel will file its report, and it's actually going to be due 2 weeks from now, right? South Africa will look at that report. South Africa will probably be very unhappy with whatever Israel says. South Africa can go back to the court and say, we want you to do another hearing on provisional measures. So this is what happened with Armenia, Azerbaijan. And we think actually Israel is not doing enough. It's not complying with the order. And so it could be that we're not done with provisional measures, if you see what I mean. I mean, it could be that this whole thing continues if the war is ongoing, obviously, right? And the court might eventually have to say more concrete things about compliance, non-compliance, about the framing of the measures and so on. But we shall see. This is very difficult to predict.
Thank you. Can I take another question from the Q&A? So this is a question by Narissa, and it's going back to the finding of plausibility of genocide. And so Narissa is asking, is there a connection now with the finding of plausibility of genocide in a conflict with duties under IHL, which are separate from the duties under the Genocide Convention? Paula, can I come to you? Is there any link at all between those two things?
Not sure to understand the question. Yeah.
As I interpret it, the way that I interpret that question is kind of saying, given that the court has found that there's a plausibility of rights with regard to genocide, does that tell us anything actually as to Israel's compliance or non-compliance with its IHL obligations, or are they just two totally separate things?
No, that goes back to what I was mentioning before. That's the question that the court has tackled a bit in the past, which is not yet tackled in a definite manner. What is the relationship between the two, no? The IHL violations and genocide. to my mind the fact that the court has found that some of the allegations, some of the acts maybe plausibly amount to a genocide committed by some state organs, in light of the enormous civilian losses and the terrible speeches that the court in part has reproduced in the provisional order. The court has not taken all of them, but some of them in the provisional order. So the court seems to be plausibly convinced that some of those civilian casualties may be the result of an unlawful IHL act. If I follow the reasoning of the court in the Croatian case, counterclaimed by Serbia, according to which for the court, only IHL unlawful acts may amount to genocide, then this may mean, therefore, that the court is also considering indirectly that Israel is violating IHL. That's a possible relationship between the two. But it's not at all clear, but it's plausible to think that the court has thought that some of the casualties, killings of civilians are the output of violations of IHL.
Okay, let's actually stick with this question of the link between a case brought under the Genocide Convention and other possible violations. So in the chat, there's a question by Michael Ramsden, who's asking whether the case might produce the unintended consequence of being counterproductive, that it might diminish the significance of other allegations given the focus on genocide. That's Michael Ramsden's question. Marco, what's your view on this?
I think that's a definite risk, and it's a horrible risk, and we've seen this happen before. I mean, let me give you an example. Everybody was talking about genocide in Darfur. Yeah, we need to mobilize, we need to prevent genocide in Darfur. A UN fact-finding commission led by our dear late friend Antonio Cassese goes there and says, you know what, we think it's crimes against humanity. We don't think there is enough evidence for genocidal intent. The next day, New York Times headline says, no genocide in Darfur, says the UN, as if crimes against humanity and war crimes are peanuts. And we've seen this with Bosnia, we've seen this with Croatia. So when the court in Bosnia said, Serbia is not responsible for the Srebrenica genocide, but there was genocide and all of the other horrible stuff, the newspaper headlines in Serbia were, we're exonerated, nothing bad happened. So I think that's a really horrible risk here, that people start fetishizing genocide, as if genocide is the only word that can capture all the bad things that can happen. And I really hate that, to be diplomatic.
Christian?
Yeah, I mean, I think I would just echo that. I mean, it's a horrible risk, precisely because, of course, the boundary between genocide and other grave atrocity crimes is so difficult to define. And we have sort of people who work on this all the time who say we shouldn't have them singled out. We should have a genre of atrocity crimes, and that is distinctive, perhaps not even by gravity, but of course we've all bought into it, and if you want, contributed to it for decades by having labels such as crime of crimes or gravest of crimes, so that we have singled it out. And of course, the topic that brought us here today is, of course, also a factor for singling out genocide, because it's the only crime that triggers access to the ICJ under Article 9 in interstate proceedings. So I think I would have so far looked at this mostly as a bonus, because it meant that at least for some crimes, there was the possibility of interstate judicial scrutiny. But of course, the risk is massive. And I mean, just to add to the list of cases mentioned by Marco, just imagine if Myanmar is not found guilty of genocide in the Rohingya case. It's a victory for Myanmar, but I mean, it doesn't make one single of the hundreds of thousands of victims of Rohingya atrocities any better off. So I think that the question is exactly on point in highlighting the risk. The question is how we deal with it, and probably not using Article 9 proceedings is the wrong way of doing it. The hope that we would have equivalence to Article 9 in conventions concerning war crimes or the crimes against humanity is slim at best, partly for reasons that Jill Barrett was mentioning in her comment, Dapo, that you read out, that there's significant reluctance to increase the compulsory or quasi-compulsory jurisdiction of the court over sensitive matters at the present time.
Okay, I'm looking at the clock and we're coming to the hour. Can I just have some final roundup remarks? First from Paula and then Danae, you may want to talk also about this issue that we've just been discussing, you know, relationship between genocide and others, and any other final remarks that you might have. And then if Marco or Christian has anything, we'll come to them next. But Paula first and then Danae.
Yes, just to follow up on Marco. Marco is perfectly right. This is disturbing that the genocide allegations do not take the big part of the discussion. But there is something that I think remains in the back door of lawyers is the state criminality problem. No? We know that the International Law Commission has abolished the notion of state criminality and state crimes, but this persists in our language. Also, Christian has spoken of the guilty of Myanmar, no, for genocide, possible guilty. Of course, the states do not commit crime if we follow the ILC argument. They just do very serious wrongful acts. And unfortunately, genocide is the only convention that the court, for the good or bad reasons, has applied also to states, keeping this criminality set for state wrongful acts. I mean, to me, states do not commit the war crimes. They commit serious violations of IHL or violations of IHL. They do commit serious violations of human rights. The crimes against humanity, war crimes, should be confined to individual criminal responsibility. And I think this has an impact also on the way we perceive this kind of debates. But that's my humble view.
Danae.
Yes, thank you. I think I agree with many of the comments of the colleagues. I think also this kind of obsession almost with genocide does not only diminish the interest on in relation to other crimes or breaches, but also the abhorrence of other crimes. But I think that an important point that perhaps should be raised is that at the moment, as Dapo knows very well, the crimes against humanity topic is being discussed in the 6th committee. The IOC has already adopted draft articles on the subject. And I think there are two questions here, whether perhaps this is the time to go for a crimes against humanity convention. But at the same time, I wonder whether this persistence of bringing cases under the Genocide Convention might create some reluctance on some states to perhaps commit themselves to a crimes against humanity convention. So I think we might see the dynamics as being both ways, but I think that all this discussion definitely has to do with the need, at least, to discuss the Crimes Against Humanity Convention. Thank you.
Okay, just looking at the clock, we've just gone past the hour mark. And in fact, one of our panelists has had to leave us because he's got another commitment. I just want, on my part, to say thank you very much to the panelists, Marko Milanovic, who's left, Professor Paula Gaeta, Professor Christian Tams, and Professor Danae Azaria for a very rich discussion. I'm sure there'll be much more to talk about on these issues. Let me hand back to Jack for some concluding remarks.
Thank you very much, Dapo. I'm sure everyone who's watching will join me, although virtually, in echoing those thanks to our speakers and to you, Dapo, for being such an excellent chair. And with that, we will close the session. I would like to express my gratitude to the events team, also at BICL, for all their assistance with this webinar. And to those of you watching, thank you for your attention, and we hope to welcome you back to another of our events at BICL soon. Thank you, everyone. Goodbye.
Thank you. Bye-bye.